Hi, I'm John Comegno from the Comegno Law Group. Is Section 504 different than the IDEA? Is the Section 504 plan different than an IEP? Are the rights of IEP students different than the rights of Section 504 students? How are they different? Are the goals of Section 504, Rehabilitation Act of 1973, different than the goals of the Individuals with Disabilities in Education Act? Where's the line? How do we decide? How do we decide which door we go in, which vehicle we use? If those lines are unclear to you, if those lines are fuzzy, if they're vague, if they're gray, to you and to your colleagues, you're not alone. That question, those questions, whether 504 is the vehicle we use to address disability or whether IEP is the vehicle we use to address disability, is a question that is plagued, that is haunted, that has teased educators across the country for 40-some years. Today, we're going to talk about the differences in these laws. We're going to talk about where 504 came from. Understanding where our disability laws evolved from aids us in understanding truly what Section 504 is and, perhaps more importantly, what it's not. Where do we begin? We begin, interestingly, in 1954. It's somewhat amazing to me that it took up until 1954 for the U.S. Supreme Court to proclaim that different, so-called separate, is not equal in public education in the United States. 1954. We look back to the 40s, the 30s, the 20s, and prior to that time. Discrimination based on all sorts of different distinguishing characteristics, demographic characteristics, was legal, was permitted. In Brown versus the Board of Education, the U.S. Supreme Court tells us that school districts can't provide different based on some arbitrary demographic. In Brown, that characteristic was race, was skin color. So-called separate but equal is not equal, is illegal, is unconstitutional. Brown didn't focus on disability. Brown didn't focus on dyslexia or autism or cognitive impairment or emotional disturbance or social maladjustment, those kinds of terms that we hear in special ed today. Didn't focus on ADHD, didn't focus on diabetes, concussion, the type of medical issues or at times educationally diagnosed difficulties we see in 504 today. But what's important to understand is that the U.S. Supreme Court in Brown told us we can't treat different based upon an arbitrary criteria, that all students, regardless, are entitled to public education across the country. 1954, 1960, 1965, 1970, are we still discriminating? Is our country still labeling? Is our country still excluding and isolating and stigmatizing? Yes, it is. Statistics in the early 1970s are that over 1 million students not educated at all, institutionalized, isolated, put in state homes, state facilities. The doors of that local school district, the doors of that neighborhood school closed. 3.5 million warehoused, not receiving any service at all. The U.S. Supreme Court recently, in the Andrew decision, talked about tragic stagnation. It's in that backdrop, it's in that climate, it's in that context that we talk about an evolution of rights of disabled persons and students for our purposes as educators. 1954, U.S. Supreme Court says in Brown, separate's not equal, can't treat differently. We see through the 1960s an evolution in awareness of civil rights. The civil rights movement gives a voice to disabled persons. It gives hope, gives opportunity to disabled persons. But disabled persons are not protected despite efforts in the Civil Rights Acts of the 1960s. There was an effort by Senator Hubert Humphrey, incidentally, who had a grandchild diagnosed with Down syndrome, to include disabled persons in the Civil Rights Act, specifically in 1964, which failed. 1954, 1960s, early 1970s, we see still that stagnation, that isolation. The first legislation that's passed that addresses disabled persons with regard to the provision of service or employment in public entities is called the Rehabilitation Act of 1973. What is the Rehabilitation Act of 1973? Have you heard of it? Do you speak of it? Do you have Rehabilitation Act plans in your schools? You don't. Because we don't refer to this law by its name. We refer to this law by its 504th section. The fact that we don't even know the name of this law only underscores our lack of awareness nationally, unfortunately, about what 504 is. It's likely that wherever you're viewing this from, your state doesn't even have state regulations. Very different than IDEA, right? So how do we understand it? Let's talk about what its intention was in 1973. Passage of the Rehabilitation Act was not focused on students in your schools that have physical or mental impairments that impact major life activities. It wasn't focused on the student with the attentional difficulty. It wasn't focused on the student with the mental health difficulty that's preventing appropriate peer relationships. It wasn't focused on the student that may have dyslexia, that may have difficulty in processing. Students who we recognize today are likely eligible for 504 accommodation. The goal and the focus of the Rehabilitation Act was to address disabled veterans coming home from the Vietnam conflict. It was discrimination against those persons that the U.S. Congress stepped up to prohibit. In fact, it took 7 years to even have enabling regulation. It took years beyond that for public schools to see an application of 504. That may explain a lack of understanding and an awareness of what 504 is today. What's the goal of 504? Centrally, if we boil it down, the goal and the intention of 504 is not to change the employment experience. It wasn't then. Today, the goal and purpose of 504 is not to change the educational experience for eligible students. In another segment, we'll talk about the eligibility criteria. Now just focusing on intent and purpose. The intent and purpose of the Rehabilitation Act is not to change the experience for our students. In fact, it is to ensure that the experience of public education for eligible students is the same. It's the same experience as their non-disabled peers are entitled to. And that's because our 504 students are not special ed students, they're general education students. We can sum up 504's intent, 4 words. Thou shalt not discriminate. Thou shalt not treat differently. Thou shalt not provide so-called separate but equal. We'll speak later as to the impact of the difficulty. We'll speak later in a different segment as to the criteria. But again, understanding what 504's goal is. 504's goal is to prevent disparate treatment. Look at the meat. The meat of 504 speaks to exclusion. It speaks to denial of benefit. It speaks to disparate treatment. The language, quote, no otherwise qualified individual with a disability. And those are all terms that we'll define in separate segments. I hope you tune into them as well. No otherwise qualified individual with a disability shall, by reason of the disability, be excluded. You can't exclude. Denied benefit of. You can't provide different. You can't deny benefit to one group of student or one individual student because they might be able to not access because of the disability. You have to accommodate or subject one to discrimination. Thou shalt not discriminate. That's the standard. Whether we're speaking of employees, whether we're speaking of students. 504's mandate is a negative mandate. Don't discriminate. 504 doesn't talk about 504 plans. 504 doesn't define a 504 committee. 504 doesn't even speak to the breadth of accommodations that we're expected to provide, and that's because its intention is not to expand or change the experience. its intention is to prevent discrimination, to ensure that the eligible student's experience is the same as the general education peers. Thou shalt not discriminate. Can't treat different. We've seen an evolution over time, an awareness, a growing awareness of what 504 is. And at some point, in my experience, the roads get crossed. 504 plans are looked at as IEP lights. They're looked at as IEP juniors. They're looked at as a step down. We should not have that perspective. We should ensure that our 504 process is a separate road than our IEP process, because the goals of these laws are separate. The intention of the Rehabilitation Act is not to expand the experience, which is part of the intention of IDEA. When we look at decisions like Rowley, U.S. Supreme Court in 1982, defining FAPE, when we look at other decisions from courts and looking at the role of parents and their participation, we may be guided by them, but we must be mindful that those decisions don't directly address and control and explain what the intention is of 504. Brown, 1954. Growing awareness of the rights of disabled persons through the 60s. The Rehabilitation Act in 1973, Section 504. Applied to public entities only, public employers, public schools. We see through the 1980s a growing awareness that disabled persons, because private employers, private entities are not specifically bound by or fall within the purview, the ambit of the Rehabilitation Act, that there's a need to address the rights of disabled persons in the private sector. So after a series of court decisions that really teed this issue up, the U.S. Congress passes, after introduction in 1989 and 1990, the Americans with Disabilities Act, the ADA. We can look to the ADA and Section 504 as almost the same. Individuals, whether they're students or whether they're employees in the private sector, protected by the ADA, follow the same eligibility criteria. The enforcement mechanisms between the ADA and 504 are the same. If we look to the law of the ADA at 42 U.S.C. 12132 and 12133, we can see there's a prohibition of discrimination on the basis of disability. Those persons may not be excluded, may not be subject to disparate treatment, may not be denied the benefits of programs. Sound familiar? Look familiar? It's the identical language from the Rehabilitation Act. In fact, the enforcement mechanisms that we see under the ADA are the same as the enforcement mechanisms under the Rehabilitation Act of 1973, or Section 504. We don't often speak to ADA in public school because ADA relates to the private sector, principally. But you should be aware that Title II of the ADA does directly apply to public schools. So that means we need to be aware of access. We need to be aware that access under Title II, as directly applied to public schools today, is another responsibility within our public schools. Hottest topic today, Title II, ADA, is service animals. But we could also be speaking to the provision of service for students with allergies. We could be speaking towards accommodations we typically see in Section 504 plans. What's the takeaway? What's the lesson? Compliance with 504 is compliance with the ADA. Compliance with Section 504's direction that we not discriminate, that we accommodate, make sure that we follow and we're consistent and compliant with Title II of the ADA. People often speak to 504's direction as leveling the playing field. You may not be aware, but playing fields aren't level. We ought to be speaking of access. We ought to be mindful that, similar to our best practices in IDEA, focusing on need and process, progress, when we speak to 504's direction, 504 focuses also on individual need. We'll be speaking in a different segment about the criteria. The criteria speaks to impact. 504's direction that we shall not discriminate looks to the impact, looks to the need. There has to be a need. This isn't driven solely by a diagnosis. We can't discriminate on the basis of that disability. How do we do that? Do we do that by developing the plan that the law requires? As I said, the law doesn't require a plan. The law requires that we be mindful of that individual need and then we accommodate that individual need. So again, and in summation, what is 504? 504 is civil rights legislation. 504 doesn't expand the rights of our students. It protects the rights of our students. Let's make sure that we're accommodating. We're not changing their experience, but we're enabling access. We're preventing exclusion. We're preventing a different experience by the provision of accommodation. I'm John Comegno. Thank you for tuning in. Be careful out there.